I would say, Justice Alito, even when you have delegations in some military cases, in emergency statutes, they have all sorts of limits. So 10 U.S.C. 2808 says that in a declaration of war or a national emergency, the president can, quote, undertake military construction necessary to support emergency use of the armed forces, but it has limits. They are tariffing the entire world in peacetime, and they are doing it and asserting a power that no president in our history has ever had. Even Justice Kavanaugh's example of Nixon, really far more limited, didn't blow past Congress's limits, as was said in Yoshida. This is a whole different animal. And maybe Congress has that power, as I agree with Justice Gorsuch. I don't think that it does. But boy, they got to say so really clearly. And here, there's nothing like that in the text of AIPA.
I just wanted to give you a chance to address kind of the other argument that's been submerged here textually. Again, just bare text for a moment, okay? We've been focused on regulate importation, but actually the statute says the president may, by means of licenses or otherwise, regulate importation. And we've had some discussion today about the fact that maybe the president could simply recharacterize these tariffs as licenses or rejigger the scheme so that they are licenses. We've also heard the suggestion that otherwise, licenses and tariffs are very similar, so otherwise might encompass tariffs there. Thoughts?
Yeah, a few thoughts, Justice Gorsuch. First is the SG is not even making that argument, and I think they're not making it for a number of reasons. One is that there's a strong presumption against reading statutes this way in the unique tax and duties context. Hartramp is one of those cases which says if there's doubt, you don't read the statute to confer such powers. Second, if you were to do that, it's open-ended. It allows, and this was your hypothetical, it allows under the word license them to tariff the world,
Seems like you're putting a major questions thumb or an interpretive lens thumb on the plain text there. Is that fair?
I think you could call it major questions. I just think it's like Justice Barrett said in Nebraska versus Biden, the most natural way of understanding what the statute is about. We're talking about, under the government's reading, a statute that gives the power to the president to junk the entire tariff.
I understand that, but you're not disputing licenses or otherwise means what it says. You're saying that we should interpret that narrowly for particular reasons.
So I think I am disputing it as well. I think the licenses, and this is something Justice Sotomayor was saying, don't expand the power. They are not verbs. And so it is limited to the 9 verbs there.
No, I understand that.
And so regulate, I don't think.
Thank you.
Thank you, counsel. Justice Thomas, anything further?
I'd like to just revisit the point that Justice Alito was making with a similar question. If one of our major trading partners, that's, for example, China, held a U.S. citizen hostage, could the president, short of embargoing or setting quotas, say the most effective way to gain leverage is to impose a tariff for the purpose of leveraging his position to recover our hostage?
No, Your Honor. So tariffs are different because they're revenue raising. And I think it goes to the point I was saying to you in our very first colloquy, which is quotas, embargoes, and stuff are different for a different reason, which is there's a tariff architecture around Title 19, in Title 19, that in tariff would, like in your hypothetical, would supersede. And here the president is seeking the power to set aside all of our trade treaties unilaterally under the word regulate. I just don't think it can bear that weight.
Justice Alito?
You mentioned other tariff provisions that you think would be rendered redundant if we adopted the government's interpretation of AIPA. One that you didn't mention, which is discussed in an amicus brief, is Section 338 of the Tariff Act of 1930. Why doesn't the plain language of that provision, which does speak specifically about duties, provide a basis for all or virtually all of the tariffs that are at issue here?
Yeah, the government's never made that argument, Justice Alito, and I think for very good reason, because it only applies to MFN violations, which are not at issue here. You can only tariff if the president, quote, finds as a fact that a country satisfies 2 conditions, including that it discriminates against the United States. There are also a host of other reasons why Section 338 may have lapsed, and that's why no president has ever used it. But look,
what is the argument that it's lapsed? It's regrettable. I mean, we put this case on a very expedited schedule, and therefore there are limitations on what and the party's ability to answer each other's arguments or arguments that are made by amici. The amicus brief says that it hasn't lapsed. There are articles that say it hasn't lapsed. What is your argument? What is the basis for your argument that it lapsed?
So two things, Justice Alito. Sections 252 and 301 have been understood by many to have superseded Section 338. And second, I don't think you have to get into this issue at all. We're not here saying that the government doesn't have a 338 power. That's something that can be decided by other courts at other times. As these folks come to the court, as the government comes to the court today, they're citing one statute and one statute only, IEPA, and we submit to you it doesn't come even close to authorizing these worldwide tariffs.
Well, what if the president tomorrow were to say, I'm reissuing these executive orders and I'm invoking, in addition to other authorities, Section 338 of the Tariff Act,
So
1930.
I think at that point we'd have that case. I mean, I'm not here to say that 338 does or doesn't do one thing. I'm responding to the government's argument, which is the invocation of IEPA and IEPA alone. But perhaps that point, Justice Alito, may
So
give
then,
the court some
I mean,
comfort.
I understand party presentation and all of that, and not being a court of first view. But in these circumstances, if that were to happen, and it might be a realistic possibility, you think, well, okay, then the government would continue to try to collect these tariffs, and the plaintiffs here would have to go back to the Court of International Trade or the district court and challenge it again, and it would have to progress through those lower courts and come back to us when? A year from now? 6 months from now? While the tariffs continue to be collected and the amount that's at stake amounts into the billions. I mean, what are we at now? 100 billion? We get up to a trillion? That's what you're suggesting?
So, Justice Alito, I think a few things. One is I think it's rich for the government to be making this argument about the refunds undermining us because they opposed the preliminary injunction in this case by saying, oh, don't worry, we'll give the refunds later. And they sought to stay in the federal circuit on exactly that ground, which was you don't need to implement the federal circuit's decision because we'll give the refunds later on. And now they're suggesting—
Well, that really wasn't my question, Mr. Kagan. The question was whether it would make more sense for us to address that, if that is a possible justification for these tariffs, for us to address that now and get it over with, rather than having this continue for who knows how long while it goes through the procedures in the lower courts.
Justice Alito, I think that is forfeited 9 ways to Sunday. This amicus brief has been filed in every single stage of this case. The government's never embraced that argument. For them to be able to do so now, I think is way, way too late. But I do think if you ruled, as we're suggesting you do, against the government, they can go and try and seek to use other authorities, whether it's 338, Section 122, et cetera. Those are the ways prescribed by the Congress. And as Justice Kavanaugh was saying earlier, every other president has used all this suite of other authorities, 201 for steel, for autos and things like that, 301 for countries like China. This president has come along and said something different, and with all due respect, we don't think IEPA allows him to do this junking of the worldwide tariff architecture.
And what were the views of President Trump's immediate predecessors on the question of imposing tariffs or allowing free trade? What was their policy view on that question?
There's been a variety of different views about that, but the executive order, my friend said, well, prior presidents had no occasion to use the tariff power, which is belied by the very executive order he's defending here, which says that the trade deficits have been large and persistent every single quarter since 1976. And we've had trade wars. President Reagan initiated different ones and the use of different authorities, but never once did a president try and seek IEPA as the basis to rewrite the entire tariff code.
I found it interesting to hear you make the non-delegation argument, Mr. Kagan. I wonder if you ever thought that your legacy as a constitutional advocate would be the man who revived the non-delegation argument.
Heck yes, Justice Alito. I think Justice Gorsuch nailed it on the head when saying that when you're dealing with a statute that is this open-ended, unlike anything we've ever seen, to give the president this kind of power. Yes, this isn't just delegation running riot. This is delegation that's a legislative application.
Wouldn't you agree that statutes that confer on the president real emergency powers are often phrased much more broadly than other statutes? Isn't it the very nature of an emergency? I know you dispute the fact that this is a real emergency, maybe it's not, but isn't it the very nature of an emergency provision that is going to be more open-ended?
So, Justice Alito, we think it actually cuts the other way. As I was saying earlier, that's what Justice Jackson said. And, you know, you already confronted that in Dames and Moore and said it's not that open-ended, even though it's an emergency. And by the way, other emergency statutes have very serious limits. Section 122 is literally about President Nixon's proclamation of an emergency. That's what it's about, and it's limited 15%, 150 days.
I mean, what about the authorization for the use of military force in 2001, which gave the president the power to use all appropriate force? Now, that's pretty open-ended. Would you apply the same non-delegation argument there that you do here?
Of course not, because there you have shared powers between the president in Article 1 and Article 2 powers. That's what I was saying.
Well, it gets into the question of whether it was delegated or not. What was the scope of the delegation?
Absolutely, but there, you know, it's military. There's a whole unique history behind that. But here you're talking about something that is exclusively committed to Congress in Article 1. And there, yes, when you have delegations, I would say, Justice Alito, even when you have delegations in some military cases, in emergency statutes, they have all sorts of limits. So 10 U.S.C. 2808 says that in a declaration of war or a national emergency, the president can, quote, undertake military construction necessary to support emergency use of the armed forces,
you very much.
but it has limits.
Justice Sotomayor?
I'm fascinated that the two instances where presidents have used their war powers to impose a tariff, Lincoln and Nixon, that Congress found it necessary to ratify their actions, and that the court in both those cases, the Intermediate Court of Appeals in Nixon and our own court, included that as part of their reasoning, as justifying the use of war power in that situation. So I'm a little concerned why the fact that this act, a domestic act on emergency, that uses a general word like regulate, should take on a war powers meaning when in every other situation, whenever Congress intended domestic taxation, it said tax and regulate.
Oh, Justice Sotomayor, I wish I had an hour to talk about this with you, because this argument by the government advanced in their reply brief is wrong, you know, every which way.
I'm saying that's your sixth way of differentiating your CETA, correct?
So
that was a war powers case.
So it's a war powers case. It's about conquered territory. It has nothing to do whatsoever with domestic tariffs. And absolutely, you're right in saying that the way that court, even in those cases, even at the height of the government's power, war powers, they said Congress had to ratify it. And that's what at page 96.
And that hasn't happened here.
And that has not happened here, not even close.
Well, it might not with Congress closed, but they can't even think about it right now. I'm going to assume, and maybe he can shake his head yes or no, that Justice Kavanaugh will ask you to go to Algonquin, which you didn't answer, and he's shaking his head. So I'll let him do that part, okay?
Excellent. Algonquin, Your Honor, is, you know, under
No, I'll let him do it.
Oh, sorry.
He can, that was his question, but I want to make sure you get to it.
We'll hear from Justice Kagan first.
I have one specific question, one more general question. The specific question is, does it matter in the way we think about IEEPA, what Congress thought it was doing in IEEPA, what IEEPA in fact did? That at the time, Congress thought it had available to it a legislative veto.
I do think it's relevant, at least for delegation purposes, because, you know, as this case comes to the court, the one check that was in there, the so-called compromise, is a legislative veto which now no longer exists. And that's why I said to Justice Alito, this statute now looks unlike any other statute with respect to
I guess I'm wondering whether, though, it cuts against you as well, that Congress thought it had a legislative veto, so didn't put in a variety of checks that it might have put in had it not thought it had a legislative veto. And, you know, that's just tough luck on Congress now.
Yeah, I don't think so. I mean, Justice Kagan, I think it's a very tough common sense argument to make because every single delegation of tariff power statute from Congress to the president always has limits, and including, Section 122 passed just right before IEPA had, in the case of the exact problem that this executive order is dealing with, large and serious trade deficits, it said the way to deal with it is 15%, 150 days. The idea that 3 years later they just said, oh no, junk the rule book, I think is very difficult, and no Congress, I think, would rely just on the legislative veto for such a thing of such momentous importance. As you said to my colleague earlier, why would any president look to all of the different tariff statutes in Title 19 if you can just IEPA them all, French Revolution them all?
General Sauer rests a lot on the president's inherent authority. And I want to make sure I understand your answer to the Chief Justice and to Justice Alito as to where you think that authority exists in a way that actually would affect our interpretation of a statute and where you think it doesn't, and why this falls into the second category, given that, in General Sauer's view, this is obviously what the Chief Justice called foreign-facing.
Yeah, so it may be foreign-facing, but there is still no Article 2 power whatsoever. There is no citation whatsoever in the government's brief to any notion that the president has Article 2 tariff authority. Now, look, I will say in wartime, conquered territory, maybe, but this is not a wartime or conquered territory statute. This is, or a use of the statute. They are tariffing the entire world in peacetime, and they are doing it, asserting a power that no president in our history has ever had. Even Justice Kavanaugh's example of Nixon, really far more limited, didn't blow past Congress's limits, as was said in Yoshida. This is a whole different animal. And maybe Congress has that power, as I agree with Justice Gorsuch. I don't think that it does, but boy, they got to say so really clearly. And here, there's nothing like that in the text of IEPA.
Thank you.